Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, we're going to discuss the K-1 fiancé visa and some specific ramifications of the K-1. As noted in other videos, the K-1 is something of an interesting visa insofar that it's a dual intent travel document. So while it's processed as a non-immigrant visa, it has this immigrant intent component to it. So it sort of processes like an immigrant visa, and it sort of operates like an immigrant visa once that individual is in the United States. As noted in other videos, the K-1, once the person that has a K-1 arrives in the USA, they have 90 days to marry their U.S. citizen fiance and adjust status to permanent residence. A question that often comes up, well, not often comes up, but a question that is asked that on one level, people think that seems sort of almost a superfluous question or almost a ridiculous sort of question to ask is, do I have to marry my fiance in the United States? Circumstances change. Things change in people's lives. A fiance visa is specifically designed in Congress's infinite wisdom back in the 50s. It was decided that 90 days is enough time for a couple to get to know each other stateside and how things are going to work, to make a decision with respect to getting married and filing for more permanent status for the foreign fiancé. But at the same time, although one must maintain a genuine intention to marry their American citizen spouse when filling out and when filing and when processing the K-1 application and petition, things can change inside the United States. I've seen situations where the couple stays together and they get married later. It didn't feel right at that particular moment to get married. It just didn't work. This happens, and so long as the foreign fiancé does not overstay the 90-day period in the United States, it's kind of a no harm, no foul situation. That being said, a subsequent K-1 after an initial K-1 can, for lack of a better term, raise some flags with respect to multiple K-1 filings, which is discussed in another video on this site or on this channel. The impact specifically on the foreign national is not particularly negative. If they did a voluntary departure, left the United States of their own free will, did not overstay their visa status, it just so happens their intentions changed, it doesn't have a negative impact on their immigration record, for lack of a better term. So this does happen. A point to note, and it's not been something that's come up frequently, but it is worth noting. The K-1 is also interesting in the fact that the K-1 is to be utilized specifically for the petitioner and beneficiary involved. So the foreign fiancé cannot utilize a K-1 to come to the United States and then, let's say, the relationship doesn't work out, but he or she meets someone else in the USA and wishes to marry that individual. It's not impossible for them to marry, but that individual that came into the country in that K-1 status cannot then utilize that K-1 to adjust status based on marriage to another party. The K-1 is specifically designed for the two named as petitioner and beneficiary. And in that set of circumstances, probably what's going to occur is that individual is going to have to leave the United States and consular process abroad and get a new visa to reflect the materially changed circumstances in a given case. Again, this is not something that comes up overly frequently, but it's something to keep in mind with respect to how this overall process works, and it provides some further insight into sort of the overall posture of the K-1 specifically.